Hi. So this project is really about applying the aesthetic functionality theory to word marks. So it asks a pretty simple and basic question, which is, why isn't there a corresponding aesthetic functionality argument for word marks? Why does it exist for designs only? And this idea came up at Whippet, I believe, was around the same time that Taylor Swift was embarking upon her campaign to trademark all her song lyrics. Such great one-liners as "Nice to meet you, where have you been?" and "Party like 1989." So, and to some, they saw this as a really smart branding strategy. Taylor Swift songs are a world brand, and undoubtedly, people probably do associate the lyrics with Taylor Swift. And I know that she embarked upon this campaign allegedly after she saw some T-shirts that had these lyrics that were made by fans. But I guess others were incensed that it seemed like a roundabout way of trying to obtain perpetual copyright protection. Currently, her marks are pending for the USPTO. They're just 1B intent to use marks. She hasn't actually used them. This is the last time I checked, which was about 2 days ago. But of course, one could see this being an issue. Suppose an author, like Shakespeare, goes out and decides when he publishes a book, he just wants to trademark snippets of what he thinks may be the best lines. And lo and behold, some lines really take off with people. Then what happens? Well, Shakespeare is now in the public domain, but if he embarked upon that really smart branding strategy decades ago, maybe he wouldn't be in the public domain. So the functionality of word marks currently are limited to literally functional phrases like "open here," "don't shake," "think green," "hi, my name is," name tags. And of so-called words with a message, which is more akin to song lyrics and Shakespeare quotes that we put on T-shirts, for example, McCarthy has two justifications for why he believes that you don't need an aesthetic functionality type argument to apply to them. And of course, McCarthy, on the one hand, is actually staunchly against the aesthetic functionality doctrine, period, and I know that a number of people are. It's a fairly controversial doctrine, so of course maybe the premise of this paper wouldn't work if you just were opposed to aesthetic functionality as a whole. But he puts forward two justifications. One is that it seems pretty obvious that if you put a word mark on a T-shirt, it would be an ornamental use. It's not source indicating. I think it's relatively well known. I don't find this very convincing because the TTAB frequently will say something is ornamental, but then they'll go ahead and they will look at whether or not it is in fact source identifying at the same time. So this happened to Lululemon a couple years ago. They were before the TTAB trying to trademark a larger version of their famous wave logo for the back of yoga pants, and the TTAB said, well, this is clearly an ornamental use. It is so big. The TTAB cited other ornamental logo types, such as the big ruffler and ponies, and not the small one, but the large pony. I think it's called Big Pony. And they said, but of course, with these marks, they're both ornamental and they're source indicative. So let's look to Lululemon's marks to figure out if, even though they're ornamental, if they can be trademarked because they're also source identifying. The TTAB decided that it wasn't, but regardless, that's an analysis that's been undertaken. And B, that sounds a little bit like McCarthy's getting the trademark use issue, which has been roundly criticized as well because it's just another means of getting at the likelihood of confusion question, which is by asking how consumers will actually perceive the mark. The second justification that McCarthy gets at is where he says such cases where words become part of the product itself are the appropriate domain of copyright law, not trademark law. He says it seems pretty obvious that you can't claim trademark protection for all the words in a novel. So this sounds a little bit like he's getting at the channeling doctrine, which Mark McKenna has applied to the traffic decision, which is a Supreme Court case involving an expired utility patent for road signs. And there, the Supreme Court at least was getting at this idea that you already applied for utility patent, it expired, you shouldn't be able to obtain perpetual patent protection by now going and claiming trade dress protection. And of course, this also was underlying the Supreme Court decision in 2003 in Daystar when they said, well, your copyright's in the public domain, so you shouldn't be able to claim a Lanham Act false designation of origin for this. So recent scholars such as Justin Hughes, in a paper they published earlier this year on aesthetic functionality, have argued that maybe the channeling doctrine is not as appropriate when you think about copyright and trademarks, because with a utility patent, you're actually telling the world this is functional. So it seems unfair that you then turn around and say, actually, no, it's ornamental, it's decorative. Justin Hughes also has this idea about how we can salvage aesthetic functionality, which is maybe we're looking at cases in which there's a pre-existing cognitive response to this idea. So it's not going to be a mark like Louis Vuitton, in which the mark holder has spent a lot of time building up goodwill in this mark, and that's why people want the Louis Vuitton insignia. Maybe it's going to be a case, maybe like the Louis Vuitton Red Sole, which was never decided by the Second Circuit because they decided the two shoes were not infringing. But maybe it's going to be something like that, where is there a pre-existing cognitive response to the color red on the bottom of a shoe because it's sexy or enticing or appealing or something like that. So these are a couple of additional formulations of the aesthetic functionality test. It's kind of all over the place, the doctrine. I think most people will agree that the Qualitex decision by the Supreme Court in 1995, even though it was technically about whether or not a color can serve as a trademark, gets at this idea of that if you take something that's widely used, it would interfere with legitimate competition. This was also underlying the Second Circuit's decision in an aesthetic functionality case involving a Baroque print for China, I believe it was, plates. And they said, well, this is obviously part of the public domain. There's a lot of China makers who put Baroque patterns on their plates, so we deem this aesthetic functional, and you can't claim trademark protection over it. This was also, the functionality analysis by looking at the public domain was also used by the TTAB in the Bottega Veneta proceeding, in which Bottega Veneta, who's a handbag maker, tried to apply for trade dress protection for their unique brand of weaving on their bags. And the examiner and the PTO had initially refused registration based on the fact that it was functional because there's a lot of different handbag makers who also use weaves on their bags. And then the TTAB actually ultimately overturned that decision because they decided that it was a very unique form of weave. But point being that functionality, frequently we look at things that are used by a lot of people that appropriately belong in the public domain. So what does this have to do with word marks? So the recent Second Circuit decision, or actually it was not by the Second Circuit, but Judge Hardy's decision in this Own Your Power case, which involved a word mark, Own Your Power, that was owned by this plaintiff who used it in connection with her mentorship services. She had like a speaking, a public speaking type company where she would go around and give inspirational speeches. That phrase was also used by Oprah, notably on the cover of her magazine, and then later on in connection with some events that she held and in which she was speaking at. So ultimately, Judge Hardy decided that Oprah's use was non-infringing, based largely in part on this idea that Own Your Power is a widely used phrase that has existed in the public domain for a long time. Oprah notably used it herself, apparently before the plaintiff first used it in a speech that she gave to Spelman College. So it was decided on this murky idea of, oh, it's widely used in the public domain, not technically on functionality grounds. So is there another way to reformulate this? Is there another way to look at whether we could apply something like aesthetic functionality to a decision like that? So phonaesthetic functionality is derived from phonology studies. Phonology studies being the study of the sound of words independent of their actual meaning. And phonaesthetics is specifically the idea of the beauty of words and independent of their meaning as well. And there's an entire discipline dedicated to this. I am not a phonologist, so in my research into this, I've discovered that there's quite a lot of literature on what makes a word or a phrase inherently pleasing. So this, for example, is a chart that was created by a phonaesthetician, I guess, who went around, he was British, obviously, because there's some very strange words in here, that he went around and he interviewed a bunch of people about what words they found beautiful. And then from that, he created a matrix of criteria basically delineating common shared characteristics of the most beautiful words. Tremulous, as you'll see, apparently satisfies all the criteria. So this highlights an interesting part about phonaesthetics, which is that you can do it with surveys. You can actually create this matrix by going out and interviewing a lot of people and seeing if you can derive common patterns from that. And that is part of the appeal of this doctrine. But then you also have this, which applies not just to single words, but to sentences, which it involves mostly poetry scholars who examine the beauty in verse and came up with specific ideas of what makes verse beautiful, a lot of it being repeated patterns and motifs. So if you can just see the italicized portions, there's different motifs. There's ones that appear intermittently, there's ones that appear as in linkage in A-B-B-A pattern. So what's appealing about specifically a phonaesthetic approach to the aesthetic functionality of word marks? Well, for one, because it's looking at the beauty in language separate and apart from meaning, you're basically looking at what Justin Hughes had said for designs of pre-existing cognitive response, right? You're not, maybe I find the idea of driving a Maserati beautiful because of the social and cultural connotations of what a Maserati stands for, but phonology wouldn't look at that. You would actually look at just the way the word sounds. And I think there, you could apply this to the Own Your Power mark. There's the repeated motif of O's, and it's emphasized in the stressed syllables. And there's you could do this not by looking to, for example, a judge's subjective impulse on what makes beauty, which is sometimes how an aesthetic functionality cases turn out, but you could do this by either calling in experts who are phonologists or actually presenting consumer surveys where you look at the beauty in words. And this doctrine wouldn't apply to everything, so consider the difference between having a motivational speech type service that you're offering called Own Your Power versus having a plumbing company called Own Your Power, right? So in one, the word is arguably the product, as McCarthy would say, and in another, it's completely secondary. Having a plumbing company called Own Your Power doesn't actually prohibit competition in the same sense that you're not selling the beauty of the words as the product, so it's not an important ingredient in your end product. So I think with that, I will take any questions. Okay, yes?
So I'm sympathetic to the concern that you're raising. I'm not sure that Taylor Swift hypo really is illustrative of the problem, right? The Own Your Power situation is perhaps a better representation of it. But from a practical standpoint, it's not clear to me how your approach will solve this problem any better than introducing a trademark use requirement, introducing a trademark injury requirement, or just litigating the likelihood of confusion issue, right? Because what you're proposing is very fact-intensive, and it requires taking surveys, calling experts, all the things that you would have to do if you were litigating a factual issue of likelihood of confusion anyway, or aesthetic functionality, right? So I guess, is there a way to retool this such that it is viable at an earlier stage of litigation where it's not just all of the same evidentiary costly mechanisms that you would have to employ if you're going to argue with no likelihood of confusion?
Right. Well, I guess the difference would be that if you actually own a valid mark that you're litigating likelihood of confusion for, you could ostensibly go after 100 defendants for different infringing uses, but with this you'd litigate it once because then your mark would be functional.
Okay, so but then you still have a collective action problem, right? Why does one defendant have the incentive to spend $500,000 proving that a particular phrase is phonoaesthetically functional? Also, I think you do have to be cognizant of the interaction between sort of pre-existing biological responses and the way that those are filtered through the commercial marketplace and the way that they're used, right? It's not that humans have one fixed response to red. We have different responses to red in different contexts based on how it's been used in the marketplace and how we perceive it. And also there are variables, right? It's not just one fixed thing. But my main concern is that you know, I'm on board, let's have a way to get rid of claims over phrases like own your power, but is this the way to do it given the evidentiary burdens it imposes?
Right. I mean, I think it doesn't actually impose that much. A trademark infringement claim is incredibly fact intensive. So if you get sued, if you're a defendant and you get sued for trademark infringement, you have to go to at least summary judgment no matter what. You're not going to disclose it on motion. So whether or not you want to throw in functionality as an additional defense that you want to, I don't know, hire a phonologist for $10,000 and stake out a consumer survey for another $50K, at the end of the day, it's going to be chump change in the grander scheme of like having an defense.
Very last thing I'll say is that Daystar is an example of where you can get something thrown out on a motion to dismiss, because if it's a communicative good, right, like a book, then it's just not actionable. And I have been involved in cases like that where someone claimed false designation of origin over imagery in a music video, right? So from a practical standpoint, if you want this to be a useful proposal, I would just encourage you to think about earlier in the case, less cost intensive, just my suggestion.
I think it's really interesting, and the question of functionality of words and phrases, I think, goes beyond questions of aesthetics in the sense of some words or phrases being more beautiful than others. I'm thinking of the Foxworthy case, where I think the court gave short shrift to the question of functionality of the comedian's catchphrase. Because I don't know that anybody's ever done a scientific study of what's funny and what isn't funny, but I do believe that expert comedians have a strong sense that some words and phrases are much funnier than others. And that's probably why some people can tell jokes well and others cannot, because paraphrasing a joke can kill the joke. So I think that, I even think Bert Lahr has been quoted as to what words are funny and what words are not funny. So beyond the sense of what is beautiful, the sense of what is funny, also, even if it's not documented by any research, there are people who I think, you know, have hands-on expertise and could even, you know, testify as an expert why this phrase is funnier than this phrase.
Oh, I'm sorry, can you tell me what court that was out of?
Foxworthy, 11th Circuit, I'm just guessing, Georgia? I can't remember if it's 11th or 7th.
Sorry, great. Thank
Foxworthy versus Custom Tees, T-E-E-S.
So given your start with the Taylor Swift example, and I think you're concerned about some of the things I am about trademark rights in short phrases, like own your power, you know, well, I wonder if just do it would do it for you. But then when you talk about phonaesthetic theory, right, what I noticed the word at the top was tremulous. So are you suggesting that tremulous would not be a good trademark because it's a beautiful word? So I think that's what I'm wondering, the fit between the theory and your concern here. And perhaps that's what you're saying, but I just wanted to be curious what your main concern is here.
Right, yeah, I think I would only be concerned if it was actually became obvious that what was being sold was the word tremulous. So tremulous is a bad example, but obviously with a Taylor Swift lyric, if you're putting it on a t-shirt, you're buying the t-shirt not because it's a t-shirt, but because it has the lyric on it. So only in those specific instances where the word really becomes the product. And it's not in the same sense where it's like you're buying Louis Vuitton because it says Louis Vuitton, right? Because that's different because they actually created that goodwill.
Well, I mean, that's maybe where the distinction is, right, between words that are inherently valuable because it's a good pun, or it's funny, or it's informational, right, where it's valuable before it's adopted by the trademark holder,
right,
like party like it's 1989, right, versus those kinds of phrases maybe that were invented by the trademark holder, where we might be more comfortable allowing them to have, you know, stronger rights in that particular phrase.
So, like everyone else, I'm trying to find the right entry point for you here, because I'm not quite sure its functionality for some of the reasons that have been said. This idea that the connection between sort of the phonaesthetics of the word and the need to use it, right? And so I'm wondering if another way to think about it is: are there certain instances, certain kinds of words for certain products, goods or services, where we might have more or less tolerance for similarity between marks because of a phonaesthetic theory? So in the area of pharmaceuticals, for example, is there a certain accepted sound that you have to have for a pharmaceutical that sort of conveys through the phonaesthetics that this is a drug as opposed to something else. And so therefore we're going to expect more things, you know, Viagra and something else is going to sound more like Viagra than it's going to sound like Pepsi, right? Because we wouldn't call a drug Pepsi. It has to sound a certain way to connote the pharmaceutical nature. And so maybe because of the phonaesthetics, we're going to tolerate similarity in certain product categories more, or we should tolerate more than we might otherwise. So anyway, just an idea for another
So you think
entry
maybe
point.
like incorporate it into when you're looking at the appearance and the similarity of the sounds of marks, is that was one of the factors?
Potentially. I mean, so I haven't, and I don't know if you posted a paper, but just based on the presentation, I'm having trouble kind of seeing this as a functionality, but I like the idea of using phonaesthetics in some way in the doctrine, so I'm trying to think about other ways where, at least to me, it feels a little bit more intuitive.
So I was wondering if you would feel differently if the word mark is from a copyrighted work, like the Taylor Swift example where there's a relatively short phrase that's from a copyrighted work, versus something like the example of "Life is Good," which is a registered trademark used on T-shirts, which clearly people must have said "Life is Good" before the T-shirt was registered. But yet it's not, it is its own, it's really emerged as a brand, and it has its own brand identity, much like a club, one might even say. But do you feel differently between those two? Is it the fact that it's copyrighted that is that relevant to the analysis or not?
Yeah, I mean, it does only in the sense that I think inherently you find something improper about trying to obtain, you know, perpetual copyright protection for something that originally was supposed to expire and go into the public domain. But I think that could be an issue of, I think Justin Hughes talks about this, whether you look at whether or not it was originally only enforced as a copyright, or when the copyright expired when it enforced the trademark. Sorry, I'm out of time, but I will